Good afternoon, everybody. Welcome to this discussion. Welcome in the name of the Geneva Academy, a joint center of the Graduate Institute and the Law Faculty of the University of Geneva. Thank you very much for coming. Thank you to all of you. Thank you especially to the panelists here on my table for being here with us today to discuss on universality. Universality is a foundational concept. We find it, of course, in the Universal Declaration of Human Rights from '48. You find the term in the founding resolution of the Human Rights Council. It is a concept with many meanings, many facets, actually. You can look at it substantively, you can look at it institutionally, and I think the realization of human rights universality, and we hear, of course, much more about that, can be approached in very different ways as well. Even through differentiated implementation. Universality is a concept which is very topical, as we see in the changing but continued attacks to its validity. The challenges that actually arise on a variety of issues and come from diverse regional and cultural backgrounds. We have chosen this topic for our panel discussion today to mark Human Rights Day, a day in advance actually, inspired by an ongoing research project at the Academy on, as the title says, universality in the Human Rights Council. You will find a brief on this ongoing research while it was distributed out there. We'll have it in the room then too. A brief on where we are with that research at the moment, on the key messages that we arrived at the moment. And one of the researchers involved in this, Joanna Bourke, will be the first speaker also today to speak about that in more details. Just for the way how I see this discussion going, I had asked each of the speakers to speak about 10 minutes, give their perspectives, and then would open up to a discussion and give it back, of course, then also to them for closing remarks. I would plan to wrap up a little bit earlier than 2:30 because two of the speakers will have to leave quickly at that time, so I'll watch the clock as we go forward. Let me now please introduce the panel to you. I will do this at once and then give them all the chance to speak and share their insights. Joanna Martignoni, to my right, is a research fellow at the Geneva Academy. Her research areas include the right to food, land commercialization, climate change, the right to education, and gender equality. She's working mainly in a big project at the Academy. It's a multidisciplinary project that involves many other academic institutions, also a project that runs till 2020 on the multidisciplinary research on right to food, land commercialization, and gendered agrarian transformation. It also has case studies in Cambodia and Ghana. In addition to the research work, she does teach at the Academy in training courses, but then also she does teach at the University of Fribourg here in Switzerland. Prior to joining the Academy, she worked also as a consultant at the Office of the UN High Commissioner for Human Rights and consulting with the UN Committee on the Elimination of Discrimination Against Women. To my immediate right, Ambassador Harper. Ambassador Harper is the permanent representative of the United States of America to the Human Rights Council. He was appointed to that post in 2014, if I understand rightly, and Mr. Harper was before a partner at the law firm Kilpatrick and Townsend in Stockton, where he was chair of the Native American Practice Group. He also serves as a member of the President's Commission on White House Fellowships, and previously Mr. Harper served as a tribal court judge and also as an adjunct professor, so we have a rich experience actually from academia to legal work and of course now the political work in the Human Rights Council. Then to my left, Professor Lyal Sunga is a visiting professor at the Raoul Wallenberg Institute for Human Rights and Humanitarian Law in Sweden and former head of the Rule of Law program of the Hague Institute for Global Justice in the Netherlands and former special advisor on human rights and humanitarian law at the IDLO, the International Development Law Organization. He has a high-level experience with the UN security and numerous international organizations. I won't name them all to save a little bit of time for the speakers afterwards. But actually, I think the experience that he has gathered in about 55 countries, working also in human rights the implementation on the ground is a very rich experience that we hope to hear also more from in relation to that topic. Professor Sunga was Human Rights Officer at the OHCHR in Geneva as well, so you see also that Geneva link to point it out, and has worked with commissions of experts also again on the field and with the field operations team at OHCHR. With this, if I may hand it over directly to our speakers and first turn to Joanna, who, as I said, jointly with the team has put a lot of thinking on what universality means in the Human Rights Council, or generally researched in how the Human Rights Council has actually dealt with it, furthered the notion maybe, or addressed the challenges. Well, Joanna, could you share with us the key messages of that project and what you see emerge so far?
Thanks very much, Felix, for the introduction. As you've stated, universality is one of the guiding principles that's contained in the mandate of the Human Rights Council that was created to embody and also promote the formal as well as the substantive dimensions of international human rights law. But what are the meanings that have been given to universality within the work of the Human Rights Council? How have these changed over the first decades of its existence? And how does universality articulate with other foundational principles of international human rights law, like respect for cultural diversity, equality, and the indivisibility and interdependence of all human rights? What challenges and opportunities do discussions on human rights universality in the Council present for the universal implementation of all human rights for all people? And these are some of the questions that we've tried to grapple with in the context of the Geneva Academy's research project on universality in the Human Rights Council. The Council itself is a big, multi-headed beast in some ways, and getting a handle on these questions has not been easy from a research perspective. And so the project itself constitutes a first step. It's a mapping of some of the trends that are apparent across some of the issues that the Council deals with. The project was started in 2015, and the outcomes have been 2 research studies that have been produced that focus on selected practice of the Council across a cross-section of different themes that are dealt with by the institution. So we looked at climate change, the right to development, terrorism and other threats to security, the rights to food, water and sanitation, maternal morbidity and mortality, cultural rights, the death penalty, human rights of migrants, traditional values and protection of the family, and non-discrimination against persons on the basis of sexual orientation and gender identity. So we tried to take a broad, perhaps not entirely representative sweep of the work of the Council, because we did also focus on particular themes where debates about universality had been noted in the past and had come to the fore. One of the studies focuses on overviewing the practice of the Council more generally, and examines specifically conceptual issues like cultural relativism, cultural diversity, and exceptionalism or exemptionalism. The second study looks more in detail at institutional dynamics and the Universal Periodic Review in particular as the site of formal forms of universality in connection both with mainstreaming initiatives and also with efforts that have been taken in order to guarantee non-discrimination and substantive equality. Both of the studies use a qualitative approach. It's desk research. We didn't go into interviewing key stakeholders, but we have suggested that as one of the next steps that could be taken to push the research further. We didn't conduct quantitative analysis, although we did rely on some secondary sources where that was the case. We use this methodology to assess changes in the Council's practice over the 10 years of its existence, and to look at where universality has entered debates, where it may have left debates. The evidence of practice was limited to available documents, so it's a desk research. We looked at voting patterns and explanatory memoranda on thematic and country resolutions, recommendations that were made, accepted or noted within the context of the Universal Periodic Review, as well as the content and the scope of thematic panel discussions, as well as decisions to engage in the development of new normative and standard-setting instruments and monitoring mechanisms. Some of the secondary sources that were used, in particular the work by the Centre for Economic and Social Rights in relation to the comparative frequency of recommendations on economic, social and cultural rights in the framework of the UPR are also cited. I have to say that one of the things that surprised us as members of the research team was the comparatively few academic studies that address the Council's work as a whole at this stage. Generally, the work has looked at particular themes, so there have been analyses of environment and climate change or sexual orientation and gender identity issues, but there's not been anything, or on particular mechanisms like the Universal Periodic Review, but there's not been anything that attempts to draw in the practice of the Council as a whole. I think we can understand why this is the case, having conducted or attempted to map this terrain, because it is vast and it's contradictory and it's slippery and it's difficult to actually come to any meaningful conclusions about the ways in which practice fits together, because often it contradicts between different mechanisms in the Council, but also across different themes. And yet there are also commonalities that we've found. As I mentioned, this is an initial mapping process. I think that additional work needs to be done, not only from a human rights standpoint, using human rights law, but also looking from a political science perspective at what actors are doing in the Council and the way this plays out in practice, and from a sociological perspective. To get into the actual content and substance of the research work, first of all, we looked at the formal aspects of universality that the Council embodies. So how are the different processes, such as the Universal Periodic Review, and the fact that the Council is mandated to consider all human rights, so civil, political, economic, social and cultural, and the right to development, as well as international humanitarian law within the framework of its mechanisms. Often the Universal Periodic Review, the UPR, is cited as an example of successful formal universality, because all members of the United Nations have agreed to be reviewed by their peers, and there seems to be a lot of momentum around that process. The only instance in which a state has declared that it was unwilling to submit to review has led to that state reneging and coming to Geneva and being reviewed after pressure from peers in the international community. So to the extent that there is participation by all states in the world, the formal universality of the process of the UPR is guaranteed. The UPR does provide opportunities for advancing on substantive universality, in that essentially the UPR process is a dialogue between, a bilateral dialogue between the recommending state and the state under review. And so there is a possibility for negotiation around issues that may be difficult or contentious. All members of the United Nations can theoretically make recommendations within the process of review. Obviously, some states are limited in their capacity to be able to do this. Many states don't have the level of representation in Geneva to allow them to be able to participate actively as peer reviewers. And another element of the formal universality that is difficult is that there's a lack of systematic follow-up within the process that would enable a real measure of the extent to which the UPR does actually act as a universalising force. While the UPR reviews are supposed to cover all of the internationally recognised human rights that are contained in the Universal Declaration and other instruments to which the states are parties, in reality the formal coverage of human rights within the UPR has been limited. And so the Academy study, as well as the study that I cited by the Centre for Economic and Social Rights, note that economic, social and cultural rights have been systematically neglected within the UPR recommendations process. And that results in comparatively fewer ESCR-focused recommendations on a limited range of topics and a lack of specificity and detail about the obligations that are connected to economic, social and cultural rights. Outside of the UPR framework, the Council has also developed other mechanisms that would enable discussions of universality to happen. So these formalised mechanisms like panel discussions and other forum for debate about contested human rights issues have certainly expanded within the past 10 years. They've increased in number from 2 in 2007 to 26 in 2016. So there has been an expansion of the range of possibilities for discussions around the content and meaning of different human rights. But again, the capacity for follow-up on all of these different thematic mechanisms has become increasingly limited as we get into a larger and larger range of topics that are being discussed within the framework of the Council. The studies by the Academy also distinguish between these formal aspects of universality and the more substantive features of universality as a concept within international human rights thinking. Obviously, that's been done for the purposes of analytical clarity, but it's very clear that the dimensions of both formal and substantive universality overlap in many regards. In connection with substantive universality, the Geneva Academy studies have highlighted the challenges grounded in appeals to moral relativism or cultural relativism, as well as those that can be classified as invoking exceptionalist or exemptionalist arguments on the basis of special circumstances. Again, the distinctions between these two categories are not necessarily watertight, and multiple justifications might be given by states for contesting different measures that have been adopted by the Council in relation to universal realisation of human rights. One important finding of the different studies is that frequently states or certain regional blocs use particularist arguments to reinforce their positions across different areas of the Council's work. So you might find the same states taking a particular stand in relation to an assertion of traditional values, but also an exceptionalist stance in connection with counter-terrorism in other areas of the Council's work. In assessing progress on the universal recognition and implementation of international human rights law through the Council, it's crucial to note that the studies document a certain degree of ambivalence. Factors that might initially appear to be conducive to or challenges to universality may at times also present opportunities. So, as mentioned, the failure of states to include recommendations on economic, social and cultural rights within the framework of the Universal Periodic Review could be perceived of and is a challenge to the indivisibility and the universality of the coverage of international human rights law. But the fact is that the few recommendations that have been made on specific topics of economic, social and cultural rights have shown a high degree of acceptance by the states that have had these recommendations issued. So that opens up spaces for future dialogue and also for progress in this area. If we look at arguments relating to the relativism or the relative universality of international human rights law within the Council, the studies highlight the idea that these arguments tend to centre on assertions that international human rights law is only valid to the extent that it accords with existing local, regional and national values and practices. The establishment of a special procedure on cultural rights in 2009 by the Council has allowed for an exploration of the ways in which cultural values and identities are defined, as well as their articulation with international human rights law. And the adoption by the Council of resolutions without a vote on harmful cultural practices like female genital mutilation and child early and forced marriages as violations of international human rights law show that there are attempts being made to fix the limits of cultural relativism by asserting the primacy of international law on gender equality. Against this trend, though, we see that since 2009 there have been preliminary studies produced by one member of the Council's Advisory Committee that led to the adoption by 5 different states of the first of several biennial thematic resolutions on the traditional values of humankind. And in 2014, the Council adopted with a recorded vote Resolution 2611 on the protection of the family, and that resolution emphasised the family as the locus of traditional, moral and cultural values. And this reassertion of traditional values has been widely seen as an attempt by certain states and regional groups within the Council to reject the modernity of international human rights law, and in particular guarantees of gender equality and the rights of LGBTI persons. Against the backdrop of this reassertion of traditional values, we find other Council mechanisms like the Working Group on Discrimination Against Women in Law and Practice, who have highlighted that these reassertions of traditional values violate guarantees in international human rights law of equality and non-discrimination. So again, this ongoing debate about relativism in the Council is ambivalent. It's something that that trends are going in several different directions, but it is important to look at when these different arguments surrounding the relativism of human rights in relation to particular local contexts and regional contexts are being made. I'll just quickly get on to a few final words about the conclusions from the study. As mentioned, debates about universality, the universality of human rights within the Council mirror broader social debates, both within and outside the UN system, concerning relationships between the international community, regional cooperation mechanisms, states and national and local communities. Prior to the establishment of the Council, a lot of discussions about universality of human rights were linked to communitarian values and the idea that individual rights guarantees were antithetical to certain regional value systems. This discussion was largely put to bed following the World Conference on Human Rights in Vienna in 1993. But since that time, and having tracked over the past decade the way in which these arguments relating to relativism and exceptionalism have made themselves known within the Council, it's clear to say that there are still those contestations around the universal validity of international human rights law. Often these include more subtle appeals to both implicit and explicit forms of exceptionalism on the basis of particular security threats or prevailing economic and environmental conditions. And the issue of cultural relativism is still present, and it's most apparent in these discussions concerning freedom of religion, women's sexual and reproductive rights, traditional values, the protection of the family, and the rights of LGBTI persons. It's important to note, though, and I think there is a growing understanding of the fact that the principle of human rights universality doesn't mean that there has to be universal or uniform application of international human rights law in the same manner in every single context. And so concepts like substantive equality require that both mainstreaming initiatives are done across the different mechanisms of the Council, as well as temporary special measures to ensure that all people can effectively enjoy human rights without any discrimination. Linked to these forms of different contextualized implementation are principles like the progressive realization of economic, social and cultural rights, and the concept of common yet differentiated responsibilities in the field of climate change and environmental law. So all of these mechanisms have been discussed within the framework of the Council's deliberations, and we can see that charting trends overall, there is now a greater discussion of issues of universality. However, this discussion has become more nuanced in a number of ways and more difficult to get a grapple on from a research perspective, but I will let others speak about the implementation and practical perspective.
Thank you very much. Yes, the implementation and practical perspective, Ambassador Harper. Now I'm very interested to hear actually your take as an insider of the Council on those issues. How did you perceive those debates in the Human Rights Council, and there may be areas that you'd like to highlight where you see universality especially promoted or especially under threat, but also maybe to see like what does that really mean for the Council as a whole. We're having the anniversary, the 10th anniversary of the Council. There's been a lot said about how the Council did actually address one of the main shortcomings of the Commission, which was a lack of universality. The UPR was cited by Joanna, but what does it mean for the Council as a whole, where we stand now in terms of universality?
Sure.
Please.
Thanks, Felix, and thanks for the invitation. You know, when I think of the issue of universality and the other key objectives of the Council to, you know, of course, the overall objective is to promote the protection of human rights. But to get there, there has to be a type of institution that's built, and one that promotes universality as a goal is key. But how do you go about doing that? I think that's what I'd like to spend some time talking about. What are the elements of the body that would aid us in achieving that overall objective? Because I think there are things that the Council can do or not do that either enhance or undermine both its legitimacy and ultimately its credibility. And I'll discuss 4 areas, and these touch upon aiding us in achieving or moving closer to universality. I think it's a goal. It's a never-ending struggle to get closer. I don't think you're ever going to really get there, but the objective is still to try to move forward towards it. And the 4 areas I'll talk about is that the institution must be or strive to be fair and even-handed. That our, you know, the Human Rights Council is a political body. It is not a juridical body. And that's very important because juridical bodies act by issuing decisions based on due process and evidence and et cetera. A political body doesn't have to do that, but the political body, to be effective and to be legitimate and to be credible, has to also be fair-minded. So that's one point, is fair-mindedness. The second point I'll talk about is that the Council has to address the worst cases of abuses and violations. The third is that the Council must act in ways that have real-world impact. And I'll talk a little bit about that. And fourth, the Council should differentiate between states that have political will and states that don't. That just because there is a human rights situation does not mean that it is the only approach is sort of condemnatory in nature. And I think what we've seen over the more recent years is a development of a better instinct to treat like cases alike and different cases differently, and that only enhances the legitimacy and credibility of the council. So let me take each one of those one by one. Even-handedness. I mean, I think that there's nothing more important to trying to achieve the goal of universality than to try to be fair with states under consideration at the council and issues under consideration at the council. And we have to strive to make sure that where there is an instance of severe human rights abuses, that we're taking that instance and treating all like cases similarly. It's not always easy because this is, again, a political body, and different states have different powers within that political body. An example of where we thought it was very important to move forward on an initiative, the United States led an initiative on reading a joint statement on China. And that is not an easy thing to do in a political body with another P5 member. But in light of some of the deteriorating human rights that we were observing in China, we thought it was necessary to read the joint statement. It sends out a larger message to smaller states that it's not just about, this is not just a place where less powerful states are going to be criticized. So it was, for us, it was very important. Another is the Ukraine resolution, which really focuses on Russia and the Russian-occupied territories, including Crimea. And so Russia is the human rights abuses of, again, these larger countries have to be brought to bear at the council. I should mention, of course, that there have been some imbalances, and one is of course, with the state of Israel. The United States takes the position, and I think it's the right position, that item 7 undermines the legitimacy of the council. Item 7 is the item number that regularizes consideration of Israel every session of the Human Rights Council. Now, we don't believe any country should be beyond scrutiny. The United States shouldn't be beyond scrutiny. Israel shouldn't be beyond scrutiny. No country should be beyond scrutiny. However, we cannot have an imbalance either. We cannot have a hyper-focus on one country. North Korea doesn't have its own item number. Iran, Eritrea. I mean, there are many, many human rights abusing states out there that do not have their own item number. And so for us, one of the reasons why the item 7 is so problematic is it undermines the ultimate credibility of the council. Again, not that these issues shouldn't be considered, but they have to be considered in a way that's balanced and relative to other states. The second area I would, and I think over time, what I would say is the council has gotten better at balancing its docket. This year, 2016, the council passed 4 resolutions on Syria, which I think is important since Syria is the biggest, largest, most problematic humanitarian situation on earth. And we passed a resolution on accountability that established a panel for accountability in DPRK. That too is an abysmal circumstances reported by the very effective Kirby Commission report. The second thing that the council has to do is it has to address the worst cases. And increasingly, it has done that. So there have been resolutions this year, 4 on Syria, 1 on South Sudan, on Eritrea, Iran, Sudan, Sri Lanka, although in the Sri Lanka example has shown an evolution, and I'll talk a little bit about that evolution momentarily, but also non-state actors. There was basically a special session on Daesh and a separate one on Boko Haram over the last couple of years, focusing on, again, non-state actors, so we're talking about human rights abuses, but ones that are critical. Why is it so important that the council address these circumstances? Because the world watches, and if you don't address those things that everybody recognizes are the worst circumstances, then you are not being effective. You're not going to be seen as legitimate. You're going to be seen as feckless. And so it's critically important that we shine a bright spotlight and do reporting on those worst cases. Now, The other thing I would say is that in one of the other things that we have to focus on, and I think this is true for international organizations generally, but particularly true for the Human Rights Council, is that we have to have initiatives that have real-world impact. That if we're talking about achieving universality or moving towards achievement of universality, it has to be initiatives that somehow, either in the near term or the long term, are calculated to change the human rights picture on the ground. And we can do that. We've seen this with, and sometimes it takes far longer than we'd like. But if you look at the debate, for example, on FGM in the international community, and where it was 15 to 20 years ago, and where it is today when resolutions are adopted by consensus, and there's initiatives by the UN and by many states to address this on the ground. These are the kinds of things that, over time, help us achieve greater universality, and it's true for a whole variety of issues. Real-world impact. Let me give you a couple of examples where I think the Council has had real-world impact. The first is Sri Lanka. 3 years ago, the Council passed a resolution which established an investigatory commission under the auspices of OHCHR. The establishment of that investigatory commission led to changes in the politics in Sri Lanka. President Mahinda Rajapaksa, President Sirisena ran against Mahinda Rajapaksa and prevailed. The arguments that he made were striking. He argued that anti-corruption, he argued against the corruption of the Rajapaksa regime, but in addition to that, the alienation of Sri Lanka from the international community, and his principal piece of evidence was the resolutions coming out of the Human Rights Council. And in the surprise election in January of 2015, he prevailed, and he committed to a reconciliation process that was based on accountability. Now, I'm not saying that everything in Sri Lanka is perfect, but what I am suggesting is that when the Council acts and is impactful, it can change the trajectory of the way a nation is going, and that can bring about change on the ground. And then, of course, this is a lever. This is not something that acts on its own. It acts together with bilateral relationships. It acts together with things like sanctions. It acts together with pushes from a variety of sources, both regional organizations, multilateral organizations, and the bilateral relationship. North Korea is also an interesting example. We haven't really seen changes on the ground, but I do think the Council's actions regarding North Korea have been very important. The Council established the Commission of Inquiry on North Korea, led by Justice Kirby, former justice on the Supreme Court of Australia. That commission came out with its report, which was a very detailed report, evidence-based, a report based on interviews by many, many victims. And it was very legal in its look and its feel. And the interesting thing that happened with North Korea is that the states that used to defend North Korea used to say, they used to argue, you can go back in the record, it's pretty clear, North Korea is not so bad. It's just these imperialist Americans and their friends, like the Japanese and the South Koreans, that are really being critical of North Korea, and it's just not as bad as they say. And then the commission report comes out, and they don't make that case anymore. Because with the imprimatur of the United Nations and the report with such great detail, with such force, the debate has shifted. Not whether North Korea has grave, systematic, and severe human rights violations and abuses, but how to address it. Now the argument on the other side is you're going about changing the situation differently, or in a wrong-headed way. That's a shift in the international debate on North Korea, and one that was caused by actions of the Human Rights Council. So we have to have real-world impact. Another place where I think we're going to have real-world impact, and why I think it was there was such a fight against it, was sexual orientation and gender identity resolution and the establishment of the independent expert. And this resolution has intentionally been focused on discrimination and violence against LGBTI persons, not beyond that. And the reason it's been so is because those are sort of accepted concepts under human rights law, that individuals should not be discriminated against, no matter what. Individuals should not have violence, no matter what. And there is a lot of violence, and there is a lot of discrimination. And just like discrimination of older persons, where there's no international definition of older persons, there is people with albinism, where we pass resolutions. There's no international definition of albinism, but we still have focused on these areas because we recognize that these groups of people are treated in ways that are both discriminatory and violently. And we appoint mandates to figure out ways to move forward. And I think that's another example of a mandate holder. It's right at the inception that will have an important change, because we will regularize consideration of sexual orientation, gender identity, the rights of LGBTI persons at the Human Rights Council. It is the area, as was noted, where we hear these arguments against universality based on culture. Look, I'm an American Indian. I know what cultural imperialism looks like. Our kids were taken away from us when four generations back, and placed into boarding schools, disallowed to speak their language, had their hairs cut, given white names, all in the words of one congressman, to kill the Indian to save the man. So that's what cultural imperialism looks like. It's not culturally imperialistic to say that you shouldn't marry 10-year-olds. It's not cultural imperialism to say you shouldn't stop women from driving cars. It's not cultural imperialism to say you shouldn't do FGM. And it's not cultural imperialism to say you shouldn't discriminate and be violent with LGBTI persons. These are nonsense arguments. And we really ought to eradicate them from the human rights discourse. Otherwise, universality will never be achieved. Finally, I think one of the things I think we've done well over the last few years in particular is differentiate between two types of countries with severe human rights problems. The Council is set up, in my estimation, to provide universal review of everybody, principally through the UPR. But it also allows for specific countries which have more serious human rights situations to be considered. But there are two kinds of countries with difficult human rights situations. There's ones with political will and those without. Let me give you an example. Central African Republic. Nobody would argue that there aren't severe human rights issues in the Central African Republic. But what is the cause of those? Well, I don't think it's a lack of political will by the leadership. In fact, I think the leadership has been quite focused on trying to address some of the issues. None of these decision makers are necessarily perfect, but it's whether or not they want to work to address the circumstances that exist. But what they don't have in the Central African Republic is strong institutions. What they don't have is systems. What they need is institutional capacity building and resources. And if we're able to build those kinds of things, then we're going to be able to enable the state to do better in addressing its human rights issues. And so there are other countries, I'd say North Korea, Eritrea, Burundi, to be sure, who seem to not have that political will. And the thing about technical assistance and institutional capacity building, it requires the will of the state. Otherwise, you're just pouring money down the drain. And in those circumstances, then the Council has to act differently. And the tools available at that time is to appoint commissions of inquiry, appoint special rapporteurs to investigate both the state and state actors in the violations of human rights. This is the key question, and it's not something that you can just ask once, because things evolve. I think in the case of Sri Lanka, for example, and now we're seeing it in Myanmar. We'd like it evolving quicker than it is, especially vis-a-vis the Rohingya. But these countries evolve as far as their human rights, and that's what we want, because we want to use the Council as a lever to improve over time. I would just make two final points in closing. The first is, I completely agree that the Universal Periodic Review, well, I would say that I think the Universal Periodic Review has been a very important addition and improvement from the Commission. And I think if you actually look at the changes, those things recommended for states, accepted by states, and then implemented, it has led to more changes on the ground in the real world than virtually any other single instrument in the history of human rights. Perhaps save the conventions, the adoption of the conventions. And so, I think the UPR is a very strong tool, but I completely agree with the notion that if we're going to move better and quicker towards universality, that we have to start focusing much more, particularly as we go into the third cycle, on implementation. That we're seeing things accepted but not implemented or half implemented, and there has to be some tool to measure state implementation of UPR recommendations. The final thing I would say is that we cannot underestimate the importance, in my estimation, of civil society and the role of civil society in achieving universality, and the importance of the Council protecting the participation of human rights defenders and civil society at the Council. One of the things that I think is most disturbing, because I think it undermines the function of the Council, is the attacks on civil society, the reprisals in civil society. I'm very happy that the UN now has an individual who will be looking at this not only for the Human Rights Council but system-wide, because the information that we can gain, the credibility through the stories that we can hear from victims is vital to us identifying new areas to explore, new concerns, new problems, and to report on existing problems that have not been improved, whether that's failure to improve vis-a-vis UPR or through other means. So civil society, I think, is kind of an area where, when we're talking about universality, when we need to find information, we need to find credible information, and civil society often is the key to doing that. So I will stop there. Thank you so much.
Thank you. Thank you very much, Ambassador Harper, for this insider view, actually, of the Human Rights Council as a mechanism, also for your call for, I guess, acting differently to upholding universality, actually, as a result. If I may turn to our third speaker, Professor Sunga, actually, hearing the previous speakers, also from our research projects, but especially then also from what we see in the Council as a mechanism, could you put that for us in perspective? Also, what comes in mind when you just think generally about human rights universality, and how actually would you see that concept relate to practical experience? The ambassador just pointed out that the whole Council doesn't really matter that much if there is no implementation, and this is really what it's there for. So how would that translate to work on the national level, and how is the importance and the practical implementation of universality there possible?
Well, thanks very much. First of all, thanks to the Geneva Academy and to Professor Robert Roth, who's sitting in the back row, for inviting me here. And it's in a way returning home, since I did my doctorate at the Graduate Institute many years ago, and Geneva was my home for quite a long time. Yes, I found the presentations really fascinating so far, and I will focus less on the institution of the Human Rights Council, and maybe focus a bit more on the conceptual foundations and the concept of universality itself, and then look at the practical aspects, as you're hinting at. Because I think that the rhetoric that you see in the Council and the kind of debates that we have, which are very politicized, and we've hinted at that already, of course, and we know that. The way to, I think, evaluate that, it could be useful to return to first principles in a way, in terms of logic and norms about universality of human rights. So I want to do that and then relate it to the practical, how does it play out practically, some of these conundrums. I wanted to start maybe by recalling something that was mentioned already, which was that the Universal Declaration of Human Rights is very much, has a very strong proclivity, or it expresses a very much a natural law conception of human rights. You see it very much in the wording. I mean, the very first line of the preamble of the Universal Declaration says, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family. And it's very nice language. Is the foundation of freedom, justice, and peace in the world. It implies that human rights and human dignity derive from the fact of being human being, from the fact of being human, and somehow is inherent in all human beings. And it posits that recognition of the fact provides a foundation for world freedom, justice, and peace. So it sounds very much like an appeal to natural law, and which might come from religious law or human nature or divine revelation as sources of human rights. And the beauty of natural law is that it's supposed to derive authoritatively from God's will or human nature, or what have you. And therefore clear and incontestable. It's why you find it in so many constitutions and human rights instruments. You find this kind of tenor and this kind of language. It also is a shortcut to saying, well, human rights are universal because it's a fact. It's a fact because as long as you have a human being, you have, human rights are deserving there. And the problem about it, there's one small difficulty of natural law approaches anyways, not with human rights, or even with universality as a concept. But with the natural law approach, is that we might not believe in natural law. And I certainly don't believe in natural law or divine law or even much in human nature. And that's not to say that we have to then throw out, this is only one conception of human rights and relating to universality. It doesn't mean we have to throw out human rights or universality because we may have some difficulties with natural law conceptions. But let me go further, because there's a point that I'm going to come to. And that is that there are some other serious difficulties with natural law approaches. One of them is that even if we agreed on which natural law to apply, which would be a huge task, I don't think we'd ever get there, it'd be extremely challenging to draw out from those general precepts very specific, enforceable rights and obligations. Another difficulty is that we have recourse to religious precepts too much, religious codes, then we find that so many religious codes, perhaps all of them, some way or other, counsel all sorts of violations of human rights. And there's a lot of contradictions and conflicts there. Moreover, naturalistic views of human rights have existed side by side for centuries with all sorts of justifications, including natural law justifications for human rights abuses, including slavery and other things. And just as a matter of pure logic, we could say that, as Scottish philosopher David Hume argued so persuasively centuries ago, can never derive really an ought from an is, or let's say human rights, the norms of human rights, from the fact of human nature or God's will or anything else like that. How is this relevant to the Human Rights Council? You might ask, where am I going with this? Foray into theoretical fantasy and natural law and St. Augustine and basically, in the shadows, everybody else, Aquinas and Finis, Rawls, etc. Well, it's that many governments that you find voting against, for example, the mandate on sexual orientation and gender identity, or for that matter, in the past, against the rights of women, very much argue from those bases that either it's in conflict with God's law in some conception or other, or that it's not natural, certain things, because of some fixed conceptions of human nature. And that, therefore, for example, certain, criminalizing activities and even the status or being, a sexual minority, or restricting women to say, well, like you mentioned, being able to drive or not drive, etc., and saying these are natural, etc. So we see very clear patterns. Well, as was mentioned already, the closer we seem to get to very personal aspects of our existence, including religion, sexual, and family matters, the more pushback there seems to be. And maybe that's not so surprising because, human rights is a progression. But it brings us to the meaning of universality itself. If we say that human rights are absolutely not universal because they cannot be consistently applied universally in all times and places, then based on that conception of universality, you would have to say that no legal norm anywhere could ever be considered universal. But that's not true. I mean, if you look at the laws against murder, I would say they're pretty universal. Even if we have a lot of differences in the precise definition of murder, or how it's applied, and even within cross jurisdictions and within jurisdictions, I would say that's a pretty universal norm. The point is that just because a legal norm might be applied differently in different places, according to time and context, doesn't mean that it is not universal. Universality has to be considered or understood, I think, and I think we've been talking along these lines, as a relative rather than an absolute property. Since we're talking about the universality of international human rights law, we have to determine the source of law. As Kelson said, it's the source of law that determines the legal validity of a norm. And as for international law, we have to look at the sources of international law. And if we look at, but it requires a qualitative rather than purely quantitative assessment. So, for example, the universality of the right not to be tortured cannot be evaluated just by counting up how many states sign and ratify the UN Torture Convention. We know that human rights law develops and interpretations develop. And naturally, there are going to be a certain amount of disputes over the universality as norms develop, norms de lege ferenda. So that's why, we are seeing quite a bit of pushback on LGBTIQ, and I'm happy the more letters we add, the better, because the whole spirit of human rights is that it should be as inclusive as possible. And so, you made the argument, I think, Ambassador, very well, that the fewer restrictions, arbitrary restrictions become sounding, they sound more and more hollow. And the more that you extend it, the closer you're getting to the universality of human rights, what is supposed to be spirit of human rights in practice. But change is not going to happen overnight. We've seen it's a difficult process. And we should probably exercise a certain amount of humility to say that even in the United States and in Canada, where I'm from, these debates have taken time themselves. And even in these countries and in other countries that have been, I would say, thankfully very progressive on these issues, there's still constituencies that would like to go backwards. They're very regressive. So I think the arguments that we make have to be insistent because of the victims and potential victims, and we're all potential victims of human rights violations. So we have to march forward. It's a struggle. But at the same time, it's something that has to be done as diplomatically as possible with persistence. For example, I was in Nigeria and arguing with people there, and I said, I was making the argument that violation of persons on the grounds of sexual orientation is a very serious thing. And it's implied very strongly in international principles of non-discrimination. It's just like racial discrimination or other arbitrary grounds. And I expected to get quite a lot of disagreement. And they said, many people with whom I was talking, said, you know what, we don't actually care that much. We never had a problem. It's the government that has a problem. And it's the government that has been whipping up this issue, and also certain religious leaders. But we never generally had a problem. We know there are people of various sexual orientation and gender identity, and it was never a difficulty for us. You find people with a bigger heart. And it's often governments that are leading these things and not victims. So one of the arguments, I think, or potential victims, the ordinary person, one of the big arguments for universality is to say, well, just to ask anybody, do you believe in the right not to be tortured, a victim or a potential victim? And they'll say, yeah, we believe in the right not to be tortured. Do you mind if it's a Western invention, even if it were, which it's not, because you find this norm coming out from everywhere. You say, we don't care where it comes from. It's a universal norm. So there are certain norms that are clearly universal, and maybe many others that should be. And I'm glad that Ambassador Harper and Joanna Bourke Martignoni also emphasize the importance of serious violations of human rights, and you can add humanitarian law and international criminal law. There we have probably the most acceptance of the universality when it comes to serious violations of human rights and humanitarian law. And you see that reflected in the statute, the Rome Statute of the International Criminal Court, which even goes so far as to expose individuals to criminal responsibility for serious violations. But as Ambassador Harper also noted, the norms de legge ferenda, the ones that are developing, for example, on sexual orientation and gender identity, are also very serious, because we are talking about violence. We're talking about violent persecution, murders. I'm traveling quite a lot in many countries, and it's a very obviously a serious issue. So we can say genocide, war crimes, and crimes against humanity, and crime of aggression are really the universal things, but at heart, in all serious violations of any of these kinds of breaches, including these newer norms which are becoming more recently recognized, the issues are basically the same in terms of physical integrity and respect. So maybe I would just leave it at that, and throw out those comments in a very chaotic, disorganized way, perhaps, and food for thought, let's say. Thanks very much.
Thank you very much, Professor Sunga, for taking us to the beginning of theories and back actually to their impact also today in the cases that you mentioned. I will give a possibility, of course, to the panelists to also respond to each other, but at the same moment would like to throw it open, as you suggest, and invite for comments and questions. Please do say who you are, and if you want to address the question to a particular speaker, also a comment, please do go ahead. So the floor is open. I'm inviting comments and questions. Yes, please.
Thank you very much for the presentations. My name is Joanna. I work for the Neutral World Federation as advocacy officer at the UN Unified Council. My question goes to Ambassador Harper, and who has got the insights with them. I'm wondering, from your experience, the especially those related to countries, to some of the countries with worse human rights record. And then the next day or so, you see member states who voted for this resolution, the foreign ministry in the capital acting differently. Example, you mentioned Eritrea, and you mentioned it, and despite the different resolutions, there is now some sort of re-engagement thing where actually the issues of human rights are a bit sidelined with some of the member states. So just want to hear what would you say on the human rights resolution, on the foreign policies, economic, diplomatic, of these countries that are engaged in serious human rights violations. And with that one also, if you could comment on, because we also get now where some countries make the distinction that we only work with the UPR, Universal Periodic Review, and anything with the special procedures, the Commission of Inquiries, that these are not, credible, and sort of try to divide the different mechanisms of the same body, of the Human Rights Council. And would this lead us to a situation where countries speak what they want and then say, if it is critical, not so say, Commission of Inquiry, because in the case of Eritrea, we've also seen that argument, not just from the government, but also from the other member states in Europe.
Thank you very much. I would invite also more comments at that moment. Yes, please. Here we're taking good note. Yes.
I'm Ahmed from the mission of the United Arab Emirates, but I work as an independent legal advisor. I'm not a diplomat, so whatever I say here, please, it does not engage my ambassador or my mission of the United Arab Emirates. So I'm an academic, and I'm reacting as such. First of all, I'm sorry with my assistant we came late because we had trouble in finding parking, etc. It was very regrettable. Since also I thank the two panelists, although I had only half of Her Excellency Harper. Universality is something which is alive in the Human Council. Wherever we speak, whatever we do, university is there. So, I have two remarks and sometimes questions. The first one is normative, since we are talking about norms. Normative one is that we have the Vienna Declaration from 1993, which in its paragraph 5 says, word by word, that considerations should be taken to the, I will quote, significance of national, regional particularities, which means specificities, and various historical, cultural, and religious backgrounds. And it seems that these provisions, unfortunately, are put aside whenever we are talking about few resolutions in the Human Council. And this takes me to the second point, which is practice. the Human Council, as His Excellency witnessed, there are few resolutions that at the end, some groups which belongs to the Arab groups, or Muslim or both, and they do not want to break the consensus, but they make some oral reservation. I don't know what are the legal significance of this oral reservation, where they say, okay, we don't have nothing against Soviet or whatever, but what we do not want is that this kind of stuff is imposed on our society, which is not suitable to their society. Now, my question is very simple. How do you react to these groups? Are they right? Are they not? And to finish my intervention, to me, as long as consensus is not reached before whatever we undertake, we cannot talk about universality. This is absolutely, it has been verified and is to be verified in the future. If we want to secure universality, and then the human rights for universality, we strive, we need to get consensus. I think.
Thank you very much. I do have another request for the floor, but will at this moment give it to the panel, and then you'll be the next speaker, because I think, well, questions were addressed to you, Ambassador Harper, but I saw others taking notes, and I'm sure you would also like to respond to a couple of the questions. So if I may first turn to you and
Sure.
then to the other
Well,
panelists.
I think those are excellent questions. Let me talk about the country-specific issues first. I'll sort of give you an insight into how at least the United States looks at country-specific resolutions. We're hoping a country-specific resolution changes the calculus, the political calculus on the ground. That's one of the intentions of it. We consider it a lever, a push in the right direction. We're about to file today a letter seeking a special session on South Sudan for next week. And part of the motivation is to push South Sudan to not do some of the actions that they are presently doing, including unprecedented levels of sexual violence, ethnically based killings, particularly in Equatoria. So our hope is that it's changing the foreign policy of these, or the policies of these countries, and we also understand, and one of the reasons why I was talking, when you're talking about the foreign policy of a country, one of the reasons why I was talking about how important it is to differentiate between those states with political will and those without, is because if states who have human rights problems and political will think, there but for the grace of God go I, they're rarely going to support your initiative on country-specific resolutions because they feel that they're just next. And so we have to say to those states who do show political will that you're not next. And you, in fact, you supporting us here helps differentiate your circumstance from those cases where states completely lack political will. And more often than we think, I do think that the political calculus is changed. I think one of the reasons why we had the special session last December on Burundi was to change that political calculus. Not only did I think it change the political calculus, but I think it helped action to occur in the Security Council, which is also very important, particularly when we're talking about a peace and security matter. On the issue of non-state actors, we're probably the most, I don't know what the term is, religious about non-state actors. But our view is that human rights is and appropriately is obligations of states to individuals, and they're restraints on states. And so the only one that can then violate a human right is a state. But that doesn't mean that, and we're seeing it more and more, that non-state actors can participate in abusive behavior of human rights, whether those are companies or individuals. But we think it's very important to maintain that structure, because I think you don't want to have more than one set of obligation holders, because I think it can become confusing law, and I think there's unintended consequences of that confusion. Now, look, I'd be the first one to admit that we're in a world, particularly with the violent extremism that has proliferated, where this is becoming difficult to hold this distinction. But at least in the Council, we've been able to hold it. If you look, for example, at the special session and the resolution that generated from the special session on Iraq 2 years ago, one of the things we did in that special session is we ensured that the focus was also on states' obligation in fighting terrorism, and that states have to adhere to international human rights norms when fighting terrorism, and not in any way to excuse the savage genocidal acts of Daesh. It's going to be an eternal continuing debate because of all these non-state actors. But I think from our point of view, it's a different set of norms that you'd be creating. I mean, where does the obligation of an individual come from to abide by these norms? It's not in any convention. So part of the reason why we're getting back to the issues of natural law or otherwise, part of the reason why the United States guards these things is because we feel we're bound by those agreements that we've entered into, and not by other agreements unless it's otherwise sort of a general customary international law, which we find in very rare circumstances. So that's part of it, is that we feel that we're bound, but our individual citizens are not bound, and that we need to keep it that way. But that's not to say that we shouldn't consider these issues. On the question here, look, I recognize that this is an important debate. You said something interesting. You said we have to wait till consensus is achieved. And I would submit that as far as international human rights norms are concerned, non-discrimination and non-violence is consensus achieved, that nobody should be the victim of violence or discrimination. Nobody, for any reason. And so what we have to do is focus the attention where it's evident that individuals are experiencing violence and discrimination based on their status, based on whether they're a woman or a minority or a person of African descent or sexual orientation and gender identity. And that's why it's important for the Council to utilize its authority and its powers and its mandates to investigate those circumstances. Others may have.
Thank you. Yes, Lyal, you wanted to come into that, and then I'll hand it to you as well. Mm-hmm.
Well, I think the last point is the one that I would start with, just to reiterate that, is that nobody is, human rights is not an attempt to exert some kind of uniformity. And it couldn't possibly be that, because the norms are very broad in any case, number one. Number two, the norms are developed by states. And when states develop these things, they have built in a fair amount of ambiguity and, let's say, general application in any case. And from a judicial point of view, there's always, the margin of appreciation, if you want to use the European Court of Human Rights approach. There's always some margin of appreciation. The difficulty is it's not elastic. Human rights norms are not so elastic that you can sign and ratify a convention and then enter a reservation that says, well, we make the norms of the Convention on the Elimination of Discrimination against of all forms of discrimination against women subject to some domestic law or religious law. That is quite illogical, because it's saying that domestic law is superior to international law. If you did that, you wouldn't have international law. The reason international human rights law developed as a series of binding legal norms, only very recently, in fact, since 1945, is because the international community recognized, had a prise de conscience, that ignoring or leaving human rights, which are so important, to domestic jurisdictions and treating them as if they were within exclusively sovereign domain is to invite, to allow governments so much latitude that it would eventually become a threat to international peace and security by basically allowing resentment and violence and things to fester. I mean, we all recognize that during the 1930s, it was difficult for countries to protest, as they did, against Nazi German policy in the jurisdiction, except to make moral arguments and political arguments, which the United States did, and so did so many other countries. But there was a lack of legal norms. After the Second World War, it became very clear that this stuff was so important. Human rights is so important that it has to be elevated to a matter of international legal concern. And so, the flexibility can be there, but as long as it doesn't go against the objects and purposes of the conventions, sign and ratify, or attempt to appeal to culture as some kind of a carte blanche. I was in Kenya some time ago, and I was talking about female genital mutilation, and saying, and I was quite pessimistic and saying, this is a very, very deeply rooted cultural practice. It's very widespread. It's bumping up against cultural arguments. It's harmful traditional practice. And somebody said to me, look, you know what? It's already making a huge impact, because a lot of people in Kenya and other countries actually don't want to practice it, but they feel like they have to. The moment you give some clear basis in international and then domestic law, and in Kenya they started to say, from the schools, you can't do this. A lot of people say, now we have an alternate authority. We don't have to go back to the customary norm, which in this instance, there are many good customary norms, but in this particular instance, it's a really nasty one. And now we can, tell our daughters or the person who's poised to go and do that, we don't have to do this. In fact, we better not, because there's a risk of punishment. Right? The pressure's off. So it's not any longer a matter of honor, and et cetera. It's a matter of law. And that's something very important about the objectification of social norms into law, is that it gives, you said regularizes, it shifts the debate into something much more respectful of human dignity, and that's the whole purpose of human rights. So from a lot of points of view, culture is important, but there's a lot of scope already in the content and texture of human rights that allows for that. It's inherently there, and that debate's going to continue. But as long as, it doesn't go into violence and everything else. And you mentioned this already, Ambassador, that and you mentioned about gays and lesbians, etc. Sexual orientation. Nobody's saying that you have to celebrate it in a particular way or recognize socially, etc. Nobody's saying that, although that would be maybe a very good thing. Just to respect people, regardless of their sexual orientation. But nobody's saying you have to do that. It's at least not sanction positively persecution and violence and everything else. You have to control that, because that's something really basic. So those are some basic
Thank
points.
you. I'd like to invite Joanna as well to comment on that.
Thank you. I just wanted to come in and share some of the remarks about the paragraph that you've cited from the Vienna Declaration. Also says that there are limits to the contextual implementation of human rights, and that has to be within the spirit of the Declaration as a whole. And that was a debate that was hammered out ahead of the adoption of the Declaration, as you know, and in terms of the Asian region's assertion of Asian values. And that was pretty roundly rejected by the World Conference on Human Rights at that time. But I think also coming back to the idea that in order to have normative universality, you have to have complete consensus on every issue. There are a lot of theorists, including Anne Naïm, who's talked a lot about the fact that these sites of contestation are actually vital to our understandings of international human rights and the way in which they can be applied in different practices. And so rather than seeing contestation as a sign of lack of universality, in fact, it should be turned around, and we should see that in a positive way, in the same way that the special procedure on cultural rights is also performing vital work in looking at, who is making claims of culture, behind the power of where those assertions are being made. We've heard that states make international human rights law, but I'd also say that there are other actors there who are making international human rights law. Civil society is also there. So it's not only people in power who are defining what culture is, and I think that those contestations are actually really, really important, and they reinforce universality rather than undermining it. And while I have a podium, can I just have a cheeky question to Ambassador Harper, because we've been talking about customary norms and practice. And one of the things that we really grappled with in the research was analysing practice within the Council, particularly with regard to consensus adoption of particular thematic resolutions. And for example, your government has joined the consensus on the resolution on the right to food, while issuing a statement saying that the United States doesn't recognise the right to food as giving rise to legal obligations under international law. And I think that for us has been one of the most difficult things engaging universal
We've achieved our objective.
On if we can interpret the fact that resolutions are adopted by a consensus, does that mean that we have universality? I think it's the flip side of the argument being made there.
Yeah. Well, if I can just answer that,
Sure.
That piece of it. I would say that when we don't break consensus on issues of this nature, particularly ESC type rights, I think the signal we're trying to send is that we may not agree with it as a norm under international law that binds us, but we also don't want to disagree with the underlying concept that this is a very good policy for us to all agree on. And so if you read those resolutions, they tend to not state that it's a right, or there's different formulations of it, or how they describe it, because we will not agree to that without having an EOP that says we don't think it's right. But what it will do is describe the importance of the issue, whether it's water or food or a variety of these things that we don't sort of see us being bound by because we haven't entered a convention that binds us pursuant to international law.
Thank you. I do invite a last round of questions, and then we'll give it back to the panel. We'll just wrap up then soon. So yes, you have been waiting from before, please. do keep the floor open, so I'll give it to you, of course, in reply then, but I do invite other comments and questions at this moment. That's the last round. We'll close afterwards, so those who would like to still get a question across, please don't be shy. Okay, well, in that case, I will give it back to the panel. I will also invite you again to what you started doing, but maybe you'd like to also refer again back to each other's interventions if there's any comments you'd like to share. And, well, can I see you're still writing the comments, so can I start with you actually, Lyal, please?
I wouldn't have anything to add at this point. Maybe if there are no more questions, I would I'll give up the floor because I don't have any particular. I think we covered the main points in regard to the questions, so I think I'm fine.
So, turning to
Sure. Well, let me take the question first. And I think it's. I'm not going to speak to the UN Security Council because that's not my bailiwick, but I can speak to the Human Rights Council because I'm the one that presses the buttons, and so I should be able to defend why I press the button. We believe that item 7 is a problem. We believe that it is the treatment of one state differently from all other states, and we will vote against a resolution because of that. And I think that that's justified. And I know other states disagree with us on that, and that's fine. But when you have one state, this is the Human Rights Council. This is not the political council. This is not some other council. This is the Human Rights Council, and we consider human rights issues. And when one state is treated completely differently from all other states, then that sends a signal that that state, and what is the purpose? The purpose is to undermine the legitimacy of Israel, which is a state that we recognize and a friend and an ally. So I would counsel towards those in the human rights community and other states to raise the issues under other items, and then we can debate them on the merits and discuss them on the merits. And I think that the United States tries to call balls and strikes. We try to vote based on our evaluation of whether or not a particular resolution reflects international norms and reflects the situation on the ground. And we don't do that when we have a separate item for one state. There's many seriously rights-abusing states, and that have been rights-abusing for a very long time. And they don't have their own item number. And I think it's just a mistake to treat one state differently from others. I do want to say one other thing that I failed to say on the cultural issue. And I think it goes to the point regarding the Vienna Declaration. I don't think that language stands for the proposition that there is an exemption from human rights norms based on culture. Because every grave human rights problem ever, from Nazism to attacks on indigenous peoples to slave trade, have all been justified by culture and religion. And so you simply can't have that, otherwise you don't have a human rights system. It's antithetical to the notion of a human rights system. Slavery, which is essentially the denial of all human rights, was justified based on culture and religion. So it's nonsensical to say you have a cultural exception. What you can say is that there are different ways to achieve the same ends, and that different societies may have different ways to meet the same objectives. But I would say one of the issues that we have all agreed one norm that we agree we will not derivate from is discrimination and violence. And I'm sorry, but you don't have a cultural exception for that, not in my judgment.
Thank you. Joanna, please.
There's another list.
If you don't mind, I just make a clarification. I didn't say that capture is an objection to any progress in human rights. I said that the Vienna Declaration says we should bear in mind, take into consideration. That's what I mean.
Yes, and I think actually Joanna has actually replied to that, but maybe if you want to come back to that point, or...
Certainly. I mean, I think that's something that is also reflected in the institutional strengthening resolution that talks about the Universal Periodic Review. There's also mention of the fact that the specificity of the development of the country should be taken into consideration where possible in the framework of the UPR. So I think that I don't know that we're necessarily at cross purposes, and I think that there is a broad-based agreement that in order to ensure effective universal protection of all human rights for all people, they need to be translated, they need to be adapted to the context in which they're being applied. But the safeguards have to be in place, and the boundaries have to be set through dialogue, through discussion in fora, including the Human Rights Council, but also I think one of the important things that we found in our study was that there needs to be also a greater connection and coherence within the council system itself and its different mechanisms, and the fact that there needs to be better dialogue across country and thematic mechanisms. There needs to be better incorporation of the work of the special procedures into debates and discussions in plenary, and also the way in which states adopt and issue recommendations in the UPR should also be more closely linked to what they're doing in terms of thematic and country work elsewhere. And then other parts of the UN system too, looking at what the treaty monitoring bodies are doing and other things, so that we have coherence and the Council does effectively fulfill its purpose of ensuring the highest standard of protection for all human rights.
Thank you very much, and those last comments have also triggered the wish for another comment by your side, so I would like to give you that possibility for your closing remarks as well.
Okay.
Lyal, please.
Thanks very much. No, I just maybe just to reiterate that, I mean, one could distinguish between development of international human rights law as a corpus of norms, and there's that debate on different governments and different civil society views around the world on how large that should be and in what shape that should take form. And then once you have the norms that are agreed upon, there's still debate, and it's always, as you said, a vibrant system that's in place on how to most effectively and in the most culturally sensitive way, perhaps in many countries, it's important to apply those things. And there's a fair, like I said before, a fair amount of scope in both those regards. But it's also been stated, I think, rather well already by others that the spirit of human rights is maximum protection, and non-discrimination is a cardinal principle. So whenever you see arbitrary grounds for discrimination and moreover attached very serious consequences in society, people getting beat up, people getting killed, people being marginalized in any way, it should be a major red flag that whatever appeals there are to culture and to excuses, justifications, one has to look very carefully at those, because they're probably not correct. And the history of human rights has very much been in enlarging the scope of human rights protection in the maximum way possible, as prejudices, as stereotypes, as old religious precepts fall in those regards. And it's not that anybody should abandon their religions or their culture, but that they have to make room for full respect for human dignity, because that is key to all of us and to our future. And we saw what happened when, and I've seen it up close in Rwanda, where human rights violations were signaled very clearly, and it was ignored. And I was involved in investigations for the Security Council back in '94, and you see thousands and thousands and thousands of bodies. And if human rights are left to individual governments, that's what you get. It's what we got during the Second World War. That's what you get any day. That's what you're getting also in Syria and a lot of other places. So if you're not extremely vigilant and you don't maximize, human rights protection, including for sexual minorities and women and children and the girl child and everybody, it's a slippery slope, and you're in a quick path to hell on earth. So I just leave it at that and make that my closing statement as well. Thanks.
Thank you very much. Thank you to all the speakers for your insights, for that interesting discussion. Thank you all for having been here, for having discussed with us. I think for me, I take really an encouragement out of that discussion also to see that our research is touching on a very important issue, and there is definitely more to be done. Also to say that we focused a lot, I think, on the cultural aspects right now. Of course, in the paper, and please do take a copy with you. It's an advanced copy. You'll be the only ones to have that. Until then, the next days we'll have it online, but this is just the printouts we brought for today. Other aspects are tackled. Terrorism was mentioned, but also I think climate change, right to development you mentioned, economic specificities invoked. So I think there's also a lot of other aspects which we didn't really get to further develop in this panel. So I think it was a very rich discussion. Again, thank you all for having been here. Thanks again to my panel, and wish you a nice afternoon. Thank you.